Good afternoon and welcome to our wills information session. This is part 2. We did the first session on the 9th of May this year, and now we are going to be talking about the estate provider benefits. And the most important thing
and welcome
is
to
to
our
ensure
wills
that we
information session.
understand.
This is part 2.
And the most important thing is to understand how one can protect their legacy. And by doing that, we've got our guest, Tibatso Moloko, who's going to be taking us through this presentation. And this presentation will also be available on our YouTube channel as EmpowerX Advisory Services. And we just want to say thank you to Ingrid for helping arrange for this session. And over to you, Tibatso, for the presentation.
Thank you very much, Bomuraro, for this opportunity to present on something that's also very, very important, that actually assists in empowering our people just to know, the difference between having a solvent estate versus having an insolvent estate, and how they can ensure that they leave a lasting legacy behind. So in our previous session, we were actually talking about, winding up estates and the importance of having a valid will in place and the dangers of dying without having a valid will in place. And so today we're looking at a product solution that will help to curb, issues of insolvency when you die with an insolvent estate, where you find that everything is now left to your creditors and your beneficiaries then do not receive anything from your estate. And this is why Momentum came up with this product. So just to give you an introduction again, I'm Tibatso Moloko, and I'm a fiduciary business development consultant at Momentum Trust. My role is obviously to give training on our service offering, which obviously incorporates our wills drafting department. We've got our estates department, and we also have our trust department. All three of these departments obviously filled with professionals. And we, like I said, under the wills department, always 3 ways in which you can get a free will at Momentum Trust. Number 1 is if you take out this product, which comes with a free will. Number 2 is if you can go onto our corporate website and you are able to then, draft a will for yourself using our system, the client direct system, where you just complete a simple questionnaire and click submit, and you can obviously pre-populate a very valid will, which is also a top quality will for yourselves as clients. Number 3 is if you get your financial advisor, who will then make use of the MyWill system to draft wills for you using the system. And also, obviously, that will also be free. But obviously, the session for today is estate provider benefit. So I am a fiduciary business development consultant at Momentum Trust to showcase, the offering that we do offer. Just to show you a little bit of our overview, so Momentum Trust service offering, I'll also take you through a brief overview of the estate administration process, and then I'll highlight the key features of the estate provider benefit product. The reason why I'm taking you back to a brief overview of the estate administration process is so that you understand why there is a need to have a product that will cap for administrative expenses when you do pass away. I'll also touch on the sequence in which monies are paid out from the cover amount the moment you pass away, because this is it's a Momentum Myriad product, and Momentum Trust is obviously the guys that handle the fiduciary side of things. So the moment you pass away, we take custody of your estate assets. We start winding up your estate as per legislation and so forth. So I will obviously explain how this process takes place and how we incorporate this product into this winding up process. There's a sequence in which monies are paid out from the cover amount, and then there's favorable underwriting for those clients who fit the selection criteria, where no blood tests would be required of those clients if they want to take out this product. And then there's also an estate provider benefit special offer, which was recently launched, And this is for existing clients, existing Myriad clients. So clients that actually do have something or business with Myriad, but do not have the estate provider benefit or do not even have a will in place. And therefore we are able to then give them the special offer, taking into account the selection criteria for that particular special offer. And then I'll head on to our concluding remarks. So this might be a bit of a shorter session than the last one. And if you do have any questions, do feel free to ask me. So number one, I think this thing is on the way. I might need to remove. Okay, there you go. This is Momentum Trust service offerings. So like I've explained, Momentum Trust is divided into 3 departments. We've got number one, the wills department, and where you have highly qualified and experienced will drafters, and we obviously use a state-of-the-art system to draft wills for you. Now, with the estate provider benefit, when you have a will at Momentum Trust, it is an easy process where you will be contacted by our consultancy. So once this product is sold and you are happy with the product, we then take in the will instructions, because a will is part and parcel of the estate provider benefit. We cannot issue the product without having a valid will in place. So this is also a product that will ensure that you do die testate versus dying intestate. Remember, dying intestate means you die with a valid will in place. If you die intestate, you die without having a valid will in place. So this product is also there to ensure that you die testate, having a valid will in place, top quality will, where we use a state-of-the-art system called the MyWill system, where we have the backing of highly qualified and experienced drafters at back office to tailor that will in accordance to your specifications. We also have a trust department for those clients who actually want to formulate trust for themselves, and they are able to do so. We've got specialists at back office who can obviously assist you with these types of trusts that we do offer. We can register the trust for you. And we obviously also have an estates department where it's also filled with professionals that are able to assist in winding up the estate from beginning to end. So all of these specialists are qualified and have got vast amounts of years of experience in winding up estates, and it's ease of business for you. It makes things easier for you. The moment you pass away, estate is reported and everything is allocated to that specific person, who will then liaise with you through your financial advisor and give you updates as to the progress of the estate. We also have like I said, we take in trusteeships so if you do have trusts and you want us to administer those trusts or take up trusteeships and be appointed as a trustee or co-trustee or whatever the case may be, we are able to give that offering as well. And for those clients that actually have offshore assets, we also do have an offshore fiduciary offering where we are partnering with a company to assist with any offshore fiduciary service. And this is everything under Momentum Trust umbrella. So I thought I should recap on what we do actually offer at Momentum Trust. That's part of ensuring that you do leave a lasting legacy and you protect your interests and the interests of your loved ones once you are no longer there. So that is the importance of everything that falls under our service offering. I just want to see, are there any questions, maybe any questions in the chat or someone wanting to ask a question?
We don't have any questions at this point. I think we can continue. Just a brief welcome to people that have joined us this afternoon. Welcome Oxnacia, Renelwe, Kediboni, and we look forward to a successful session. So make use of the chat functionality should you have any questions that you'd like to ask. And let's make this session an informative one, a productive one, so that we can benefit and leave a lasting legacy to the next generation.
Thank you very much. So now I just want to take you through a brief overview of the estate administration process. I did go through this process in the previous session. I just want to also give you a recap of this, just to show you how it is important to have this product in place. So obviously, when you pass away, first thing that happens is you obviously, when someone passes away, your family members have to, number one, ensure that they obtain a death certificate from Home Affairs. And then we need to put the house upside down, as we usually do, to try and see if we're able to pay for the funeral. Are we able to cater for any expenses that may arise? Is there a valid will in place? Once we have all that information, we are able to arrange for the funeral, and we know that we know who to contact and so forth. Now, in such an instance where there is a valid will in place and Momentum Trust is the appointed executor, Momentum Trust will have our legal advisor, one of our legal advisors, driving or flying to any address in the country to do what we call a preliminary interview. So they can either drive, fly, or have a team session with the family members of the deceased clients to do what we call a preliminary interview. In this preliminary interview, our legal advisor will, number one, read out the will to the family members of the deceased clients, just to ensure that you understand that your family member had a will. These are the clauses. This is how he or she wanted his estate to be distributed, and so forth. So that's part of the preliminary interview. Our legal advisor will also request for documents and will obviously assist you in completing reporting documents that need to be lodged at the Master of the High Court. So remember, when someone passes away, their estate may need to be reported at the Master of the High Court. Now, there are reporting documents that can be downloaded on the Master's portal, but our legal advisor will have these documents in place. And these documents, our legal advisor will assist the family members in completing it. This is a service that we do offer. As you may know, sometimes when you try and report the estate yourself at the Master of the High Court, you're going to stand in queues. They're just going to give you these documents. And if you don't understand how to complete these documents, it can be quite a lengthy and tedious process for you, because then you don't even know what to do. You don't understand half of the things in those documents, and you might require professional assistance. So the perks of having Momentum Trust is we've got a legal advisor that will assist you in completing these reporting documents. As soon as these have been completed, they will be accompanied by the original will, which also needs to be lodged at the Master of the High Court, certified copy of the deceased ID, marriage certificate if that's applicable, copy of the executor's ID. In this case, if Momentum is appointed, the nominee of Momentum Trust, this ID will also be attached to these documents. We then lodge these documents at the Master of the High Court. Now, this is, we can do a change of jurisdiction looking at which Master of the High Court is most efficient, and we are able to then lodge the documents there. And the Master of the High Court will then peruse these documents and double check that everything is in order. And if they are happy, then they issue a relevant letter. If they're not happy, if there's something outstanding, they will also issue a query and say, kindly clarify this, and they list whatever it is that needs to be clarified. Or they might even say, okay, kindly furnish us with this because this is outstanding, and we are able then to provide the Master of the High Court with whatever it is that is outstanding. If the Master has perused the documents and they're happy with everything, then they issue either a letter of authority or a letter of executorship. Now, the difference between these two letters is the value of the estate. So if the value of the estate is below 250,000 rand, then the Master of the High Court issues a letter of authority. If the value of the estate is above 250,000 rand, then the Master of the High Court issues a letter of executorship. So that's the difference between the two letters. The estimated value of the estate will determine which letter the Master of the High Court will then issue. In the case of a letter of authority, whoever's appointed can act as a master's representative. And in the case of a letter of executorship, which is issued for estates above 250,000 rand, the master, whoever's appointed, can then, take custody of the estate assets and can begin the winding up process. And now there's certain functions of an executor once they are appointed by the Master of the High Court. And winding up an estate can be quite lengthy and tedious, which is why it is always rather advisable that you do get a professional that actually specializes in winding up estates, as opposed to just going to anyone that you believe may be able to assist you. So it's very, very important that you do a background check. Number one, where do you have your will drafted? Is this person qualified to draft a will? Do they specialize in estates, wills, and trusts, and so forth? So these are the things you need to look into when you make these types of decisions regarding your legacy, to ensure that your legacy is in the right hands and it is going to be distributed, and ensure that it is lasting for those you do leave behind. In a perfect world, winding up an estate, 9 to 12 months in a perfect world. Every estate has its own merits. Sometimes it might take, even over a year, depending on the merits of each case, sometimes even less than a year to finalize a particular estate. And like I said, once the master has issued a letter of executorship, there's certain functions that an executor would need to do, which is why you may require a professional. Just want to show you some of the duties of an executor. Number one, the executor would need to take custody of the estate assets, not own, but take custody until such time as they're discharged by the Master of the High Court. But two, the executor would do what we call a Section 29 advertisement. And this Section 29 advertisement needs to be published in a local newspaper and in the Government Gazette. And the purpose of this advertisement is to serve a notice to any creditors that may have a claim against the estate, and it gives them at least 30 days from the date of the newspaper publication to lodge your claim against the estate. Now, what creditors am I talking about? I'm talking about your Absa Home Loans, Nedbank MFC, FNB Home Loans, whatever the case may be. Edgar's, Foschini, I'm just naming these creditors that would still want to lodge their claims against the estate. I'm just giving you practical examples. If you die or pass away having owed these creditors money, they are able to lodge a claim against your estate, and are obviously assisted through the Section 29 advertisement. And in virtue of having the estate provide a benefit, this advertisement can then be paid for by the product itself, because that's part of the purpose of this product. Something else that an executor would need to do is to open up an estate-led bank account for the estate in the name of the estate. And the purpose of this account is so that all the proceeds that belong into this estate are paid into this estate. And the executor also uses this account to pay those successful creditors that have claims against the estate. In other words, if they succeed in their claims, we then utilize these proceeds in the bank account to pay those successful creditors and so forth. Something else that the executor would obviously require or need to do is to send out letters to various financial institutions. Number one, requesting certificate of balances from each of these institutions. So for example, I always give examples with the 4 big banks, or the banks, not necessarily the 4 big banks, but the banks that we do know. Capitec will say, client has this amount of money in his savings account with us, and that's a certificate they issue. FNB will do the same, Absa will do the same, Nedbank will do the same, African Bank will do the same, and they issue these certificate of balances through to the executor, and the executor will then use this certificate of balances as vouchers when they draft what we call a liquidation and distribution account. This liquidation and distribution account, I don't want to be too technical, but this liquidation and distribution account will contain assets of the deceased, liabilities of the deceased. It just shows the taxes that need to be paid for. I'm trying to simplify it as much as this account needs to then be lodged at the Master of the High Court and must lie for inspection, and an advertisement also needs to be placed for this account. And anyone who objects against this account can lodge their claims within 21 days from the publication. So that's the purpose of this certificate of balances. In the same letter that the executor issues out to these financial institutions, he will request them to close off all those accounts and pay in all those proceeds into this estate bank account that the executor would have obviously opened. And after gathering all of that information, remember this is just a summary. After gathering all of this information, the executor is able to determine solvency and liquidity. Again, solvency is asking, having looked at the estate, do the assets exceed the liabilities? If that's a yes, then that's a solvent estate. If the liabilities exceed the assets, that's an insolvent estate. And liquidity, on the other hand, is asking, is there enough money in the estate to pay for administrative expenses? Remember, when you pass away, a lot of people are not told about these things. When you pass away, it's not just the funeral that we need to cater for. The fact that there's an estate that needs to be administered, we need to cater for all those administrative expenses, all those professional fees, which is why Myriad, in collaboration with Momentum Trust, came up with this product called the Estate Provider Benefit Product, which is made there to ensure that you've got enough money for these administrative expenses and professional fees, which I will touch on when we highlight the key features of the product. So it's not just the funeral that we need to take care of, it's the administrative expenses after the funeral, once the estate is being wound up, that we need to cater for, because if you do not make provision for those expenses, things need to be sold. That's when we sell that Mercedes-Benz that your father or mother or family member has left behind. That's when we sell that piece of furniture to ensure that there's enough cash in the estate and so forth. So there are many, many instances where you find that an estate is actually solvent, but there isn't enough liquidity, in other words, cash in the estate. These are referred to cash shortfall estates, and these types of estates can amount to 70% of delays in winding up process. This is why I say every estate has its own merits, and it's very, very important that you ensure that you leave enough money. You leave enough money, and if you do not have enough money, have a financial advisor like Bomuraro who will advise you on what products to take out to ensure that your estate is not only solvent but also liquid. Just want to check, are there any questions?
The question that we had was someone asking about the website where they can download the will from. So I've indicated that we will be able to assist, and then we'll send them the information accordingly. And that the website is also the Momentum website, as you've previously indicated.
100%. So if you go onto the Momentum website, you should find a tab there that says Client Direct, and you are able to complete a questionnaire where you can basically draft your own will in there by completing the questionnaire. So it's very straightforward. You don't even have to have the legal technical knowledge to utilize the Client Direct system. It's very, very easy to use. It is on our corporate website. No other questions, I assume, on the floor.
No other questions at this point. Just want to remind everyone that they can make use of the chat functionality should they have any questions, and to also welcome Ingrid, who has joined us from Momentum. So welcome, Ingrid, and we look forward to engaging with you. You can also make use of the chat functionality. I know you've got issues with your Zoom, so that's why I'm saying you can use the chat, but if it's sorted, you're most welcome to come in.
Okay.
And assist. And to some is, so as EmpowerX, we are an authorized financial services provider, and Momentum is one of the services providers that we work with. So we provide with financial advice and also intermediary services. And with intermediary is to help link you with the product suppliers in line with fulfilling the needs that we've identified when we're putting together or helping you put together your financial plan. So if you need anything, feel free to contact us, and then we'll be happy to assist. We can continue.
Thank you. Thank you. So this is basically just some of the duties of an executor, and very, very important. You not only have a solvent estate, but also a liquid estate. And just remember, solvency is where assets exceed liabilities, and liquidity is cash. Is there enough cash in the estate, which is very, very important when you do pass away. Obviously, through the aid of your financial advisor, you should be able to leave a lasting legacy, because your financial advisor should ensure and will ensure that in your financial plan, you do incorporate estate planning. Now, just to touch on the key features of the estate provider benefit. So the estate provider benefit will cover for administrative expenses that arise during the winding up of the estate, such as the following. So number one, executors fees. So executors fees are unavoidable. I'm sure a lot of you may have heard of the term executors fees. These are provided for by legislation. So the moment you pass away, you must know that your estate may be liable for executors fees. And in terms of the section 51, 1A and B of the Deceased Estate Administrations Act, this section basically says that anyone tasked with winding up of an estate, having been appointed as an executor, is entitled to, so A says, any amount that may be fixed in a will. B says if there is no amount fixed in the will, then an executor is entitled to at least 3.5% of the gross value of the estate, and obviously VAT if the executor is registered for VAT. So executors' fees are unavoidable. They are provided for by this particular section. Conveyancing fees. Estate provider benefit will obviously then cover for these executors' fees. And then when secondly, conveyancing fees. So conveyancing fees are basically fees that you might also be liable for, your estate may also be liable for the moment you pass away, especially for those of you who do have immovable properties. So remember, movable properties are your cars and your furniture and so forth. Immovable properties are your houses, basically. So that's the difference. And so with houses, you may need to transfer the house from the name of the deceased to the names of the beneficiary, and that's an administrative expense, generally based on the value of the property and the tariffs of the law society. The good thing about this product is that we do have an EPB calculator that is able to help us to determine how much of these conveyancing fees would your estate be liable for, based on the information that you would have provided for us, looking into the value of your property and so forth. And this calculator that we do have is in line with the latest tariffs of the law society. So whenever the law society amends their tariffs when it comes to conveyancing fees, we also amend the calculator to ensure that it is in line with the latest tariffs. So these conveyancing fees can be quite expensive, generally looking at the value of the property. And some people wonder, well, I'm married to my spouse in community of property, so I own the house in any case. Remember, if you are married in community of property, it means you probably own 50% of the house. So it will be important that the other 50% of your spouses is transferred into your name when they pass away, because you might not be able to sell the house if you only own 50%. So the other 50 also needs to be transferred into your name from your late spouse's name, and that will require a conveyancer. And this is obviously an admitted attorney who has written and passed their conveyancing exam. So their fees can be quite pricey. And on virtue of having the estate provider benefit product, these expenses is already covered by the estate provider benefit product. This is obviously able to ensure that if you do have any cash in your estate that would have gone to these conveyancing fees, is then unaltered and left for your beneficiaries as well. Vehicle transfer costs. So to transfer the vehicle from the name of the deceased to the name of the beneficiary, That's an administrative expense that your estate would have had to pay for. Virtue of having this product, the estate provider benefit will cover for this product. Master's fees. Remember, when you pass away, we have to report the estate at the Master of the High Court by completing the reporting documents that are available on the portal. Now, on virtue of us utilizing the Master of the High Court, they are entitled to master's fees. And it's based on a scale that they do use at the Master of the High Court, looking at the value of the estate as well. And some people may ask, but why do we have to pay the Master of the High Court? The Master of the High Court has an advisory function. So if there are any family disputes, the Master would be there to advise. They've got a supervisory function. They've got an administrative function. So the fact that we lodge documents there and they peruse the documents, that's admin. So that's an administrative function, and that is why they are entitled to fees. Master's fees, minimum 600 Rand, up to 7,000 Rand in master's fees that you can actually pay for. So it's based on the scale that they do use. And the good thing about our calculator is that it is also able to help us to determine how much master's fees your estate may be liable for. And these are also included into the cover amount of this product. Testamentary trust fees. Our wills also make provision for the creation of a testamentary trust. And now remember, a testamentary trust is a trust that is established after you have passed away for the benefit of maybe your minor children. So if you've got minor children, or if you've got an elderly parent that you've been taking care of, or someone else that you know that they're unable to, take care of their financials and so forth, then you can make provision in your will for the creation of this trust. And you have professional trustees like Momentum Trust who are able to establish this trust for you and run the trust for you, invest whatever it is that you do put in trust in an interest-bearing account for the benefit of your children. And in your will, you are able to elect that you want the trust to terminate when the child is either 18, wherein they are old enough to take care of their finances. If you're comfortable with that, receiving the money when they're 18, they can receive it while they're 18. If you want them to receive it at an older age, you are able to do so. If you want partial releases of the trust capital, in other words, what that means is you can say, I want them to receive 30% at age 21. And then after they finish their degree, maybe at 25, they can receive their full inheritance and that trust can be terminated. And that's the importance of having a trust in that. If you do have a trust in place, it's invested for the benefit of your beneficiaries, and your beneficiaries are taken care of by this trust. If they need money for school fees, for clothing, and anything, we've got trustees, we've got your financial advisor, who will also still remain the financial advisor of your children whilst this trust is running, and so forth. So that's the importance and the perks of having a testamentary trust. If you do not make in your will provision for the creation of this testamentary trust, your estate may be reduced to cash and paid over to the Guardians Fund. The Guardians Fund is a department at the Master of the High Court, and whoever you appoint as the guardian of your minor children will have to approach the Guardians Fund from time to time requesting monies for school fees, for clothing, and so forth. And that obviously entails standing in a long queue at the Master of the High Court. And sometimes you might stand in that long queue and it might be cut and you have to come the following day and so forth. So these are some of the things that you might need to look into in considering making provision for a testamentary trust, where you do know that you've got especially minor children that you do leave behind. Because remember, minor children cannot inherit in their own personal capacity. So if you have a trust set up for them, you've got professional trustees that will ensure that the finances are okay. When the child wants a 21st birthday, trustees will look into the financials to see if there's money to have that 21st birthday or that 16th, sweet 16th birthday. If they want clothing, if they want a vehicle, and if there's enough money in trust, they can utilize it. So those are the packs. And testamentary trust fees can be quite expensive as well. because they are based on the duration of the trust. So the longer the trust runs, the more expensive it becomes. And through our EPB calculator, we are also able to determine how much these testamentary trust fees can be. And we then incorporate those fees into the cover amount of the product. Firearm costs. The estate provider benefit will cover for the collection, storage, and relicensing of these firearms. And the very strict rules when it comes to firearms, it's taken care of in terms of the Firearms Control Act. And so when you do have firearms, it can be quite expensive. If you look into our EPB calculator as well, for 5 firearms, it can be an easy 12,500 rand just for the collection, storage, and relicensing of a firearm. Because if you have a firearm lying around in your house and it is unlicensed, or you do not have a license to handle that firearm, then it needs to be taken care of by professionals, because it could be criminal that you keep those firearms lying around in the house if you're not licensed to do that. So this product will ensure that there is money for the collection, storage, and to relicense that particular firearm, and obviously the fees will be covered by the product. And therefore, if you do have any cash in your estate, that will be for the benefit of your children.
Okay, that's quite interesting. Yeah, the firearm part. So there's a question that we have here. I think you've covered part of it when you were explaining the testamentary trust fees. The question says, hello everyone, is it true that trust funds protect your assets? If so, how does it work?
Okay, so in this case, if you're talking about trusts to protect your assets, we're not necessarily talking about a testamentary trust, because remember, a testamentary trust is more for the benefit of your minor children, where it is only set up after you have passed away. But we've got other trusts wherein instead of buying the house under your personal estate, you buy it under this trust. And that means if anything goes wrong under your personal estate, in other words, you become insolvent, or you owe creditors and you become insolvent, those creditors cannot come after those assets that are under a trust. Because if they're under a trust, they do not form part of your personal estate. They are protected under this trust, because under this trust, generally 3 parties. You are the founder of the trust. There are trustees who run the trust. These are the professionals. And you've got beneficiaries, who are the beneficiaries you would have chosen to benefit from that particular trust. And therefore, the assets in the trust belong to the beneficiaries, and they are protected from any creditors because they are under the particular trust. I hope that does answer your question. Okay. And then other key features. So the other key features where the estate provider benefit will cover 100% of the executor's fees for all estates that are below 10 million. And obviously, on virtue of having this product, you are automatically receiving discounts in executor's fees, such as the following. So if the value of your estate is between 0 and 2.5 million, you get a 10% discount. The value of your estate is between 2.5 million and 5 million, you get a 20% discount. If the value of your estate is between 5 million and 7.5 million, you get a 25% discount. And if the value of your estate is between 7.5 million and 10 million, you get a 30% discount. Now, if the value of your estate is above 10 million, we work it out separately, where we give you, for the first 10 million, 30% discount in executors' fees. And then the balance that's above 10 million, we give you a 50% discount. So for example, if the estate is worth 20 million, we give you a 30% discount for the first 10 million. And then we give you a 50% discount in executors' fees for the next 10 million. And these are the concessions we do offer. These are the discounts that are offered when it comes to the estate provider benefit product. And as far as we know, these are unlike any other product on the market, as far as we know, when it comes to discounts in executives fees. So it's something that you need to look into. Very, very important, these discounts, because what this means is that if there's on top of us covering those executives fees and you get discounts in those executives fees, it means there's more cash for your beneficiaries. And I'll explain why as we move along through the presentation. By the way, just to mention, some of our competitors, they only give you discounts when the estate is worth 7 million rand upwards. Everyone else would pay the normal rate of 3.5. So we give you a discount in executives fees from Rand 0. Very important. Something else that's a perk about this product is that, remember, it's a myriad product. So what happens is when you pass away, Myriad will take the benefit lump sum paid over to Momentum Trust. We utilize it for those administrative expenses that I've mentioned in the previous slide. Executors fees, conveyancing fees, vehicle transfer costs, master's fees, and so forth. Now, looking at the benefit lump sum, if there's any residue, in other words, if there's any amounts left from the cover amount of the benefit, these are then paid to your beneficiaries or used for any other debt that you may be liable for, or that your estate may be liable for. So in other words, if you've got this cash and that's utilized and there's monies left, it's given to your beneficiaries or used to cover any other debt that your estate may be liable for. This is because we are capital insurance, and most, if not all, our competitors are indemnity insurance. Now, let me maybe give you an explanation of the difference between the two. So capital insurance is basically insurance where the insurer undertakes to pay a specific amount as stipulated in the insurance contract at the happening of the insured event, and we utilize the full benefit lump sum at the happening of the insured event. Indemnity insurance, on the other hand, which is what our competitors are, is insurance where the insured event, should it occur, must result in a quantifiable amount, and only the quantifiable amount may be recovered, nothing more, nothing less. Let me maybe give you practical examples of the difference between the two. Capital insurance, which is what we are as the estate provider benefit product, you've got R1 million worth of the estate provider benefit product. Once we pay for those expenses that arise when you pass away, like executors fees, conveyancing fees, vehicle transfer costs, and all of these, maybe there's a residue left. Let's assume you've got R1 million worth of this cover, and after paying for all of that, you've got 400,000 Rand left. Or maybe these administrative expenses cost you 600,000 Rand, and the remainder is 400,000. This 400,000 is paid over to your beneficiaries or used for any debt that you may have. Indemnity insurance, on the other hand, you've got R1 million worth of the product, expenses are amount to 600,000, the remainder is 400,000, the remaining 400,000, they don't even mention, they keep to themselves. They don't even talk about it, they don't even mention it to you. And that is the perk of rather capital insurance as opposed to indemnity insurance. And so that's one of the main differentiators between ourselves and our competitors out there in the market. And then another perk about this product, I know it's a lot of information, but another perk is that there's an instant cash paid to a nominated beneficiary within 48 hours of the claim being made. In other words, you need to nominate a beneficiary for this instant cash. This instant cash is normally 10% of the cover amount, but it is maxed at 50,000 Rand. So it's 10% of the cover amount, but maxed at 50,000 Rand. So minimum cover for this product is 300,000. And there is no maximum cover for this product because we do a calculation, and whatever we get in the calculator, you can then be covered for subject to underwriting and so forth. that needs to take place before then. And obviously it needs to be accepted. So there's 10% of the cover amount maxed at 50,000 rand. And the good thing about this instant cash is they can utilize it for, you know, the funeral. They can utilize it for the benefit of the children or the family until the estate is wound up or whatever the case may be. But another perk with this is that it is not aggregated with any other myriad instant cash. For example, if you've got a myriad death benefit and you've got this estate provider benefit, which was also a myriad product, you can get both instant cashes because it also has an instant cash. And it can give you a maximum of 100,000 rand in instant cash that you can obviously utilize for the funeral because it's paid within 48 hours, or you can utilize it for the survival of the family until the estate has been wound up and so forth. So that's another perk of this product. And then, like I mentioned before, when you have the estate provider benefit, it does come with a free will where no explicit drafting fees are charged for that particular will. And with this will, like I said, we've got professional consultants that will contact you to take in the will information, and they will draft the will for you. So you don't even have to worry about anything. And then they will obviously send it to you to double check if it's okay. Something that I didn't mention about our wills is that we do have a dedicated team at back office that will ensure, number one, that the will is in line with the Wills Act and it is tailored in accordance to your specifications. So if you want it worded in a certain way, we are able to tailor it in accordance to your specifications, at the same time ensuring that it is in line with the Wills Act, because it's very, very important that your will is not illegal, immoral, or even vague, so that it is not set aside by the Master of the High Court once you have passed away, because this thing happens. And we do have a dedicated team that will conduct a thorough legality check before this will is placed in our safe custody vault, because there's a lot of wills that have been drafted out there, and you find that it's not in line with the Wills Act. Therefore, the master needs to reject that and declare it invalid because it's not in line with the Wills Act. So it's very, very important that you have a professionally drafted will that is tailored to your unique circumstances as well. So the perks of having a financial advisor like Umuraro is that they are able to have a financial plan for you that we as the back office fiduciary office will then look at the financial plan and ensure that it is in line with your financial plan. Because if you have a will that's not in line with your financial plan, it might not be executable when you pass away. And, it may be set aside and your estate may have to be administered in terms of interstate succession. Again, a perk of having this will is that you can amend it and review it as many times as you want without incurring any additional costs whatsoever. In other words, it's free, these amendments. So if you acquire new property, if you want to disinherit someone, if there's a change in your marital status, if you have an additional member of the family that you want to add, or if you want to make changes, you can do that as many times as you want. I know that with some of our competitors, you can only do it like once or twice a year, and beyond that, you pay for any amendments that you do make there. And obviously, we do have a water and fireproof safe custody vault, and this will can be collected at any address in the country on which you're having this product. So if you do have this product, we arrange for courier on our side to have that will collected, and we can keep it in our safe custody vault. When you pass away, we remove it and we utilize it in order to wind up your estate, and we ensure that it is lodged at the Master of the High Court. And that is the perk of having us as your fiduciary specialist. And this is the perk and the key features of the estate provider benefit. Are there any questions so far?
The question that we have is, how do you deal with houses in rural areas under chiefs and indunas?
Yes. So
No, I was talking about movable assets, so houses in rural areas and chiefs
Yeah.
in
Those are they generally do not have much value in that, but we obviously would have to administer them as per your will. So if your will says we're giving it to so and so, it will go directly to so and so. But when it comes to valuing those assets, I don't think they'd have much of a value in that aspect, because I've never heard of transferring or conveying a certain property from in a rural area. But it's something we can obviously get that information for you.
Yes, please, because on the value part, I was gonna say come to Limpopo.
Yeah.
You will see that there's value in the houses that we build here.
Especially Venda. I've seen houses that look like malls up there.
Mm-hmm.
I've seen houses that look like a mall up there in Thohoyandou. That is true. But yeah, we can definitely find out from our back office how they actually do that from our estates department. Maybe other questions that you may have? No other questions? Nothing in the chat?
Nothing at this point.
Okay. Now, a sequence in which monies are paid out from the cover amount. So remember, this is a Myriad product, and then they take the full benefit lump sum and they pay it over to Momentum Trust. So first thing that will come out is instant cash, which is paid within 48 hours of us receiving the death certificate and so forth. And then executors' fees will come from the benefit lump sum as well. Just to explain something about executors' fees, so we take a minimum from the cover amount of 50,000 rand or 3.5% of the value of the estate from the benefit lump sum, not from the estate, but from the benefit lump sum. The reason why our minimum is 50 is because we take in all types of estates regardless of the size of the estate, wherein under normal circumstances, if the estate is a Section 18.3 estate, remember I said a Section 18.3 estate is an estate that is below 250,000 rand. Generally, trust companies do not take in those types of estates because they are too small and there's no fees to be made from those estates. So trust companies generally do not take in Section 18.3 estates, and that can leave a burden on the loved ones that you do leave behind, because it's either they're going to try and report the estate themselves, or they're going to approach an attorney who might charge for just about everything from walking into their office to their tea, to all the telephone calls, to all the emails that they do send out. Then you get an invoice on an estate that's not even worth much to begin with. So this product enables us to take in those small estates that are Section 18.3 estates as well. So we take in all types of estates regardless of the size of the estate. And then there's an advisory fee to the financial advisor and a share in the executor's fees to them. And then, there's also favorable underwriting that's available to those clients that actually fit selection criteria where no blood will be required from those persons. And this is the following. So if you're below the age of 46 at your next birthday, cover amount is below 750,000 rand, and you have a clean bill of health and no bloods will be required from those particular clients. So if you fall within all three, so if you're below the age of 46 at your next birthday, amount is below 750 and you have a clean bill of health, and no bloods would be required from that particular client. And then there's also a special offer that is launched for those existing Myriad clients who do not have this product in place, and they can obviously get up to R1 million worth of the estate provider benefit cover amount without any underwriting whatsoever, and they are able to receive it. But this is more specific to your financial advisor, so they can get up to R1 million, like I already mentioned, and they can get a top quality will from Momentum Trust without any underwriting. And this is also a way to ensure that a lasting legacy is obviously left behind for your loved ones. And so just to give you the selection criteria, I'm skipping some of the slides because they're not so important, just to show you the selection criteria. If you below the age of 55 at your next birthday, and you have been fully underwritten within the last 6 months, and the contract is still in place, and your existing Myriad cover was issued at standard rates, and you've not previously submitted any life insurance claim, and this cover should not replace any of your other cover. This is just for the special offer, not for the product itself, but the special offer that's available. So this is more direct to those advisors who will look into their clients' profiles and so forth. And so, yeah, my concluding remarks: never underestimate the importance of proper financial planning in making sure that your will is executable and easy to administer. And it is imperative that you make provision for your estate to put your loved ones at ease when you pass away, and always ensure that your estate is not only solvent, but also liquid, because if it's just solvent, it means your beneficiaries might be losing that BMW or that piece of furniture that they have sentimental attachment to because you do not have enough cash in your estate. So these are some of the things that you need to look into, and through the aid of your financial advisor, you should be able to have a solution that will cap some of the things that we do experience on a daily basis. Because in life, we generally look at these families where we grow up very wealthy, but then you find that the moment the parents pass away, all of those assets disappear. And in most cases, it's due to these administrative expenses that I've been touching on. And this is one of those solutions that you can think of in order to ensure that they cover for those administrative expenses. Remember, the estate provider benefit doesn't only cover for those administrative expenses, it also covers for any debt that you may have left behind, like your outstanding home loan, outstanding vehicle finance, any debt that you may have. And it also incorporates any taxes. So if you owe SARS, because SARS can be a nightmare for some estates. I don't know if you know about a very famous Johannesburg businessman who passed away, and he had lots and lots of assets. He had like 100 cars, houses all over the country. And when he passed away, his estate was worth zero because of the money he owed SARS. So through this product, you are able to include that debt that you owe SARS into the cover amount. So when you pass away, this product will ensure that that debt is paid off. And obviously, if you incorporate this cover amount and it's huge and there's residue left, the monies from the cover amount can be given to your children or beneficiaries, or utilized for any other debt that the executor can obviously discover during the winding up process. And that is obviously the end of our presentation. I don't know if there are any other questions, maybe.
Thank you very much for the presentation. We don't have any more questions on the chat. I think we can just conclude by putting the disclaimer that we should have put when we started, to say that this session is purely for information purposes And this session does not constitute advice. So if there's anyone that's looking for specific advice, you're most welcome to reach out to us and then we'll be able to assist. I'm Muralo Nematayeni from EmpowerX Advisory Services, and you can reach us on 083-261-0700, 083-261-0700, or info@empowerx.co.za, and we'll be happy to assist. Thank you once again, Tibatso, for taking the time and educating our people with regards to understanding how to protect their legacy and how to use these products that are available in order to ensure that the benefits for their children and the next generation are well protected. And thank you, Ingrid, for joining us and being part of this session. And to everyone that has joined us, I see we've got people from different sectors. We've got attorneys, we've got people that are housewives, we've got people that are students, we've got people that are professionals in different fields. And this, I just want to invite you to extend and share about this recording and this information that was shared with people within your network, because there's so much value in knowing other than just ignoring, because when we need this information, it's important that we know where to find it. So you're most welcome to like or subscribe to our YouTube channel, and then contact us should you need any assistance. Thank you. Any closing remarks from your side, Tibatso?
Very, very important. Ensure that you do have a will as in today, because remember the dangers of passing away without a will, interstate succession, where the law will then decide how your estate is to be administered, and you can have actually unintended beneficiaries actually benefiting from your estate just by the small mistake of not having a valid will in place. So something to really, really think about. Very important. We need to pass away with at least having documented our wishes on a valid will, even if it means jotting down your wishes on a piece of paper. As long as it's in line with the Wills Act, then that piece of paper can be accepted as valid by the Master of the High Court. But like I've already said, there are many, many ways where you can actually get a free will for yourself. So it doesn't have to be expensive to get a will. There are 3 ways through Momentum Trust where you can get a valid will for yourself. So ensure that you do have a will today. Very, very important. Thank you very much.
Thank you.